Hey, everybody. Welcome to Reimagining Healthcare, a new dialogue with risk and patient safety leaders presented by MedPlace. We're excited to bring you conversations with top risk and patient safety thought leaders from organizations around the country. If you like what you heard, share it, talk about it. We'd love to also invite you, if you're interested, to come be a speaker. Really, anybody who's got an opinion on risk and patient safety that we think is interesting, and it can cover a lot of different angles, just reach out to us at speakers@medplace.com. So today, I'm excited to unpack a topic with you guys, and really, this is going to be driven by our guest. My name is Jared Bailey. I'm the CEO of MedPlace. I'll be playing host today. But today, we're joined by Dr. Scott D. Buchholz, the managing partner and senior trial lawyer of Dummett, Buchholz, and Trapp. Did I get that right, by the way, Scott?
You got it right, except I'm not a doctor, although I'm a Juris Doctor, a doctor of law, but I don't have the privilege of having a medical license.
Oh my gosh, did I say doctor? That's funny. I think I saw the D and it threw me off. So Scott specializes in civil litigation with emphasis in professional liability, commercial and business litigation, as well as arbitration and administrative licensing matters. He regularly consults with healthcare institutions on regulatory and compliance issues. So Scott, welcome.
Hey, thank you very much, Jared. Appreciate the opportunity to chat today.
Yeah, of course. So you're going to help us out. You're going to help us understand and unpack this new MICRA law thing that happened in California, right? So what are we dealing with here? What is this, and how did we get here?
Yeah, thank you, Jared. And just by way of background, I work with hospitals and physician groups in defense of their medical malpractice cases, and so we're very much involved. My firm is very much involved with dealing with MICRA, which is a set of laws, the genesis of which came about in the 70s. California, always being rather litigious state, there were no caps on damages. And in the 70s, the early 70s, the insurance companies that insure doctors and hospitals were raising their premiums. In 1975, they were going to raise premiums 400%. And so what we saw were doctors leaving the state.
Wow.
And this was a significant issue. And there was bipartisan support for let's do something about it. We have to do something to bring premiums in and make sure that our doctors and healthcare providers, anyone that has insurance or can be sued, has some protection. So the legislature came up with what was AB 1XX that was signed into law by Jerry Brown in 1975, and what this package of laws, and we'll talk about it briefly, is it was meant to control costs and decrease professional liability premiums, and was a compromise amongst the various parties, the plaintiffs' bar, as well as organizations that supported doctors. So that's what we've been tied to without any significant changes since 1975. And
Okay.
how we've gotten here now, maybe, and how we've gotten here now is we jump ahead to 2022, and the centerpiece of the MICRA legislation was a cap on pain and suffering, which was capped since 1975 at $250,000. That amount has the buying power of about $50,000 now. So there was a strong push, and there has been over the past 6 or 7 years to change that up. So let me talk a little bit about what MICRA is. MICRA is the Medical Injury Compensation Reform Act of 1975.
Okay. That's our starting point for all this.
That is the starting point. That is the law in 1975, and really was the bell cow for a lot of legislation around the country. California was at the forefront of this because of this soaring premiums. So the centerpiece, as I mentioned, is this cap on pain and suffering, general damages. There's no cap on economic damages. If someone is wronged by a medical provider, They could still get their loss of income. They could still get their medical bills paid. They could still get other costs. But when it came to general damages, or what we call pain and suffering, that was capped at $250. Another aspect of this micro law was capping or limiting contingency fees. This was a big issue for the plaintiff's bar, and actually part of the new law that comes in. So plaintiff's attorneys, unlike other agreements in cases such as a car accident or slip and fall, they can ask for 33%, up to 40%, I've seen, even more, of attorney's fees out of a settlement or jury verdict or judgment. Micra limited it from 1975, 40% of the first $50,000, and it was a scale based upon the amount of the recovery.
Okay.
So what, in effect, this limitation incentivized many attorneys from getting into the cases, not only because the recovery was capped, but also what they were going to be paid. And believe me, medical malpractice cases are fact intensive. They're difficult to work up. They're expensive, and attorneys really shun that area because of the what they would be paid and what their clients would receive.
Okay, makes sense.
Yeah. So there are other aspects. Another issue was collateral source, which is if you're in a car accident, you could introduce your medical bills that were paid.
Huh.
In California, the legislature determined that we are not going to require a medical provider who is sued to pay medical bills of the injured party as a result of it. They wanted to. They felt that for policy reasons' sake, they felt that they could remove that. So that we're able to avoid having to pay most medical bills in medical negligence cases if we're a defendant and we lose. Now, the differences are that doesn't cover Medicare or Medi-Cal. Those are federally based programs, and state law wouldn't cover that. Another aspect of Micra, and there are like 6 areas, was a shortened statute of limitations. If you wanted to sue a doctor or a hospital, you would have to bring the case within 1 year.
Wow.
Yeah, it's 2 years for general liability, car accident, things like that. Now, 1 year, it's not a rock solid. It's when you reasonably should have discovered the event.
Oh, okay.
Yeah.
A
So
little
there's
bit
a
of leeway
difference
there. Yeah.
For example, if you have a surgery and the doctor and the surgical team happens to leave a sponge in, and you don't know about it, and you only find out about it later, the statute of limitations wouldn't be 1 year.
I see.
So that's something. And then there was a couple of other aspects. One, you were required, you're required to serve a notice of intent in advance of suing a hospital or doctor to give the opportunity or some breathing space with regard to possible settlement. And that would extend the statute of limitations from 1 year to 1 year and 90 days.
Okay.
The last aspect, and again, I know I've been talking a little bit here, it's a rather involved group of laws, is that healthcare providers, if there's economic damages, let's say you have a high earning injured patient who has damages, a good deal of damages, you can periodicize payments. You don't have to give a lump sum up front. If the jury, it can be periodicized over time.
Okay.
Up to $50,000. If we have more than $50,000, they can periodicize it, which can save the defense costs because you can structure it.
Yeah.
So that was the micro framework, and that's what we lived with for 45 years,
Wow.
up until now 47 years, actually, up until AB 35 passed.
Wow. So, I mean, Scott, these are some pretty significant structural changes. And many of them that you just mentioned are economically, going to drive certain behavior from the plaintiff side I mean, that's why this is a big deal, right?
Right. We haven't got to I haven't started on the changes to the law, but that's what we've lived with. And that
Okay.
is the framework that has allowed the state of California, when it comes to per capita payouts and damages, to be in the bottom third of states.
Interesting.
And that has allowed premiums and for providers to not be enormous, manageable, uh,
Sure.
because costs have been limited. And in fact, in my area of practice, because we have some cap on pain and suffering, there's less risk
Yeah.
involved in lawsuits.
Yeah, that's right. And I know because I've seen legislation in various compliance laws from California end up driving decisions and trends in other states that I'm sure others are looking at what's going on here, and we'll see models of this, or we'll see echoes of these changes moving into other states over time. But so what are these changes? You did a good job of establishing the foundation. What are we really looking at?
Well, there are some significant changes. Let me say that one thing that's not included in MICRA that is part of Assembly Bill 35 is a broadening of the ability for a frank discussion with a patient by a doctor.
Hmm.
Under current law, uh, if a doctor talks to a patient and says, I'm very sorry that you had to go through this, it's very unfortunate. Um, Feeling statements of benevolence, empathy can be mentioned. But if that doctor said, I'm sorry, that was my fault. I should have removed the sponge before I closed the body cavity. That would be admissible, and that would
Mhm.
be an admission of fault. What this law includes is now a new section within the Health and Safety Code that will not only allow for expressions of regret or sympathy, but include statements of fault. So a
Hmm.
doctor,
So those statements are now protected in
they're
some capacity?
they're protected. They will not be admissible into evidence, and that will be a significant. What the hope, I suppose, is to allow for a more open and frank physician-patient communication, which is at the heart of any procedure. Is the informed consent and discussion about what has occurred. So that will be interesting to see how it plays out.
Scott, you're familiar with the CRP programs, communication resolution programs?
Yes.
This sure sounds like it opens the door and maybe even necessitates that hospitals and providers within California, if they haven't adopted it or don't know how to spell it yet, they might want to start looking into it, because this opens the door to that being a potential solution, or a potential at least tool in the toolkit to help fend off. I mean, that's how it's being used today to really help resolve things earlier, and not lead to some of these larger nuclear verdicts, things like that.
Yeah. No. As it should be. I think Stanford and Michigan were really at the forefront of
Yeah.
these programs. In California, up until January 1, 2023, when these laws take effect, there'll now be opportunities. But before that, um, it was because of admissibility of statements of fault. Uh, and potential exposure, that placed a bit of a cap on these things. So, but that aspect of the law is something that's nuanced. It's not something that is contained within the old microstatute. So let's talk about
Great.
what is new. Okay. Instead of a flat cap of $250,000 on pain and suffering, we have a built-in graduated step process. So what the legislature has done is break out caps into two parts. For your medical negligence without a wrongful death, the cap will increase to $350,000 year one. For your wrongful death cases, the cap will go to $500,000 in year one.
Okay.
Every year after that, for the non-wrongful death cases, it'll increase $40,000 up until year 10.
Okay, so is this referring to like claims that are filed within these years, that's where the caps will be set to that claim? Is that the idea?
Yes, sir.
Okay,
The lawsuits that are filed after January 1.
lawsuits. Okay, great.
Yeah, or it could be an arbitration, a petition for arbitration versus civil action.
When that event happens will trigger what the cap is going to be on that particular case.
Correct.
Got it.
Correct. And
Okay, so
then
these escalate over the years then.
exactly. So the cap on the non-wrongful death matters, the sponge case that we spoke about, where there wasn't a fatal result, that would be $40,000 per year, up to $750,000 in year 10.
See.
Thereafter, it increases 2% per annum.
Okay. So it's
So
going to start, considering inflation. I mean, I think inflation's a little bit higher than 2% these days, but at least that component's in there now. So we don't have the same situation where, decades later, we're still, providing the same caps.
exactly.
I see.
And for wrongful death, it'll be $50,000 up to $1 million in year 10. And again, same 2% boost each year after that.
Okay.
So another new aspect as it relates to MICRA is something called stacking. So what the law says is that, well, let me go back a moment. If a case went to trial and there was a doctor, a hospital, and say a physical therapist that were sued, and there was a jury verdict against all three, the most the plaintiff could get would be $250,000 in general damages because of the cap.
Okay. Yep.
The new law creates a stacking opportunity for an injured patient. If he sued the doctor, the hospital, and let's say downstream after the event at the hospital, the patient saw a physical therapist who did something wrong, that he could stack or she could stack all three. You have
Wow.
the opportunity to sue the doctor and the hospital and the downstream provider who's unaffiliated with the doctor or the hospital for a separate cap. So potentially a plaintiff in a sponge case or something like that, where there is no wrongful death, you could have 3 caps. So for pain and suffering.
Wow. So the caps that you just walked me through,
Mhm.
it would be those caps potentially 2, 3, 4 times in one case.
3 times, as
Three
much as 3
times in this
times.
particular case, right?
So what
Wow.
used to be on December 31st, the case was filed prior to that, the potential for 3 defendants will be $250,000 in general damages. That same claim filed on January 1 could be 3 times $350,000, which could be $1,050,000. So that's a 400% increase in potential losses or strike that the potential damage claim. So that's a significant addition um, to what the exposure is.
I mean, this
And
is going to require that carriers and captives completely, that they're going to have to completely recalculate how they're looking at all of their risk, obviously. This is a significant math change to that calculus.
huge,
Yeah.
huge. And I think it will have ripple effects. The premium certainly will go up. Hospitals, I mean, the issue that hospitals often have is they are, under California law, often held as the principal of doctors, that is the agents. We call it ostensible agency. It's really a judicial creation that if a patient comes to a hospital, they just see a big building. They don't know who's an employee. They don't know who's an independent contractor. And hospitals are having to deal with hospital-based practices, emergency room, radiology, pathology, anesthesiology, and distancing themselves from those providers, making sure that the conditions of admission say that the doctors are independent contractors, doing anything they can because they could be held responsible for the actions under California law if they don't make an affirmative representation as to the contractor status of the doctor. But
Mm.
it is something that this is going to send ripple effects, and I think the hospitals, medical staffs, or hospitals are going to require more coverage
Yeah.
instead of the 1 million, 3 million.
Yep. And, it's creating a lot of economic incentive to get more attorneys to enter the space and to get them to take on more cases. I mean, it's really changing the calculus for them also. So I imagine we're just going to see a volume increase in general as a result of this too. So I think in a lot of ways, this, I understand why, this is such a big deal and why this is a big deal for others in that country. Because if there are states that start to follow suit, then, this isn't just going to be a California thing.
Yeah, and interestingly, there haven't been a lot of states that have adopted similar laws to micro. In fact, many states have found caps on damages to be unconstitutional, invading the legislature, invading the judicial duties under their constitution as far as limiting damages. And so, but we'll see. I mean, there's a lot that is covered in the new law. There are things that are not covered. Evidence of collateral source. We still get to avoid having to pay medical bills unless Medicare. The statute of limitations has not changed. What has changed is the contingency fees. Instead of looking at steps along the way, how much is recovered, what the legislature has done is said that plaintiffs' attorneys can collect 25% of cases that are settled before litigation, and then 33% of recovery after judgment, strike that, after a judgment or a lawsuit is filed.
Okay.
If matters are tried, taken to trial and arbitration, and trials can be very expensive,
Oh, yeah.
the plaintiff's attorney can petition the court for additional monies beyond the 33%. So
Interesting.
the combination of the ability to obtain additional damages, the higher return for the plaintiff's bar, I think is going to bring back to the fold successful general liability plaintiff attorneys and other personal injury attorneys back to medical malpractice cases. So that,
Indeed.
yeah. There is a change regarding the periodicizing of patients' payments, damages from 50,000 to 250, but that I don't think that's going to be a major issue here uh, for micro. It's going to create any ripples anywhere.
Well, Scott, tell me if there's anything else new with the law that we should cover, but I'm interested, if we get our crystal ball out, what, what kind of, what could we expect from, in terms of like creative pleadings from plaintiff counsel, or, what tactics might be used to sort of maximize or to just take advantage of this higher recovery potential? Like what does your crystal ball show you? What do you think we
Uh,
should be at least have on our radar and kind of looking for?
well, there really isn't much. I mean, it's sort of a turnkey operation for the plaintiffs. I mean, they're going to be making similar claims. There's nothing. We'll talk briefly about the ballot measure that was to be on the November ballot. That included a requirement of a certificate of merit before plaintiff counsel filed a lawsuit. That this is not part of this new law. But I think what we're going to see is naming of additional defendants because to create stacking.
Yeah,
Uh, and we're gonna,
100%.
yep, we're going to see
Yeah.
that. Uh, we're obviously going to see delays in filing of lawsuits, assuming the statute of limitation allows. I've already seen in a couple of cases that we have where we have minors whose statute of limitations are longer, considering the plaintiff's attorneys considering dismissing the claims and then refiling them after January 1.
Interesting.
And to allow for the greater payoff at the end. Plaintiff's bar has been very creative thus far in trying to get around the micro cap. They've been utilizing a law, the Elder Abuse and Dependent Adult Civil Protection Act, and this is an act that really is there to protect elders and those who are dependent uh, uh, from cases of neglect.
Okay.
That is not covered under micro. But the access or ability to utilize that law, anyone who's been in the hospital for more than 24 hours can actually be considered a dependent adult. And so we see that law often utilized. Whether or not there's greater use or less use of that law with the new micro caps, we'll see how that goes.
Mm-hmm. Yeah, I can imagine that might change, it might not. So how does this sort of change medical malpractice cases, like for patients or physicians, for small practices, large systems? Like how are these different stakeholders affected potentially?
Well, with reimbursement not increasing, uh, with increased regulation. I mean, healthcare is the most regulated industry there is. I mean, you've
Yeah.
got federal, state, each hospital, ambulatory care centers often also are accredited in order to be part of the Medicare program. You have licensing boards, physician. I mean, there's so much going on in this area from the standpoint of oversight. The cost to maintain that, I think, is going to be a significant concern for small medical practices. I think you're going to see greater consolidation in the industry because you've got to create some economies of scale as far
Right.
as cost. I think you're going to see less. I think you're going to see more health systems taking on medical groups because they just won't be able to afford, these premiums, which are going to go up, and they're going to continue to go up. And so I think as far as that's concerned, I mean, I've been working in this industry, uh, defending hospitals and doctors since 1988 in California, 89, excuse me. And I've always been impressed with the risk and quality that services and resources that are done in in this space. And I think that there's just going to be a greater focus on that, more money spent to that.
Mm,
I think that someone is going to have to pay for these higher damage results, and really, we're going to see more litigation, and no one really talks about uh, the cost involved in those 90% of cases that are disposed of. I mean,
mm,
to defend a case in a med mal case where you have to have a medical expert
mhm.
uh, in order to, from the plaintiff standpoint, and we usually retain experts also. It's $150,000 at least. And then you're talking about the folks that have to come offline to be interviewed or deposed or things like that. There's a
Yeah.
significant cost. We're going to see a great deal more claims. We're going to see a lot more lawsuits, and there's going to be a greater burden on providers. So
Indeed. Well, and we've certainly, it's not hard to get the crystal ball up because, there's other states that have not had these same caps and limitations. So, we kind of look at how things play out there and kind of get an idea of how they'll work in a place like California. So, but yeah, there's in other places, there's a lot of attention to how to create more efficiencies in the prep part of the process. I mean, MedPlace is born out of that desire to create efficiencies in working up cases and in litigating them and things like that. So, I'm sure there's going to be some of that going on to help kind of counterbalance it. But if I think about it, I could probably think of a couple of stakeholders that are benefiting most from this bill. Like who would you say is benefiting the most from this bill?
well, I, I certainly think that injured patients who have valid medical malpractice claims will benefit. Uh,
Sure.
there's obviously a greater opportunity for damages here, and so I think that is significant uh, a significant thing. I also think that the plaintiffs bar uh, and the legal industry is going to benefit.
Yeah.
If, frankly, it'll be more work for me, so I suppose I benefit.
Hmm.
I, I'm not sold that on the idea that patients generally benefit, because I think that the more litigation leads to more defensive medicine and greater costs, and litigation and is a leakage in a system.
Yeah.
Medicare doesn't reimburse for it. Medi-Cal doesn't reimburse for it. And it is a leakage in the system that, you know, whether right or wrong, it always comes down to scarcity.
Yeah.
I
That's
mean,
right. Well, we've got the Fairness for Injured Patients Act too out there. So what is that? And how does that relate to AB 35? Is this because we talked about patients benefiting? Is this a move in the right direction? Like, help me understand these two.
well, the Fairness for Injured Patients Act is actually, and I have to check on this, but the promise was that they would remove that off the ballot with the signing of AB 35.
Ah, okay.
And so that law would have done a good deal of that would have been much more significant from the healthcare provider side than what was come up with AB 35. So it's my understanding, Gerard, that this is not going to be going to ballot. That with AB 35, that Fairness for Injured Patients Act will no longer be considered.
Got it. Okay, good to know. So just to kind of close up, feel free to give me any other closing ideas that you've got. But we did just touch on whether this will have a national impact. What's your kind of final thoughts on that? I mean, it sounds like maybe, maybe not.
You know, it. I think eventually, uh, the federal government will step in at some point with its own program, national program versus sort of uh, each state having their own.
Yeah.
I mean, we're talking about a very integrated uh, health system throughout the United States. So I think we'll see the federal government come in and probably set their own laws eventually in healthcare. As far as other states are concerned, it really depends how strong their uh, medical. We have in California a very strong medical physician lobby group, uh, which has done well to keep MICRA as it was in 1975. Um, and I'm not so sure that the ballot measure that was on the ballot would have been successful. A ballot measure, similar ballot measure was in 2014 was soundly defeated. Um, I think people still have a halo with doctors, especially after COVID. Um, but the same. Uh, I think other states will certainly consider it, but I think at the end, if the federal government doesn't come in, the state will need to come in. And I think, like I believe Florida does this, the providers will only need to pay a certain amount, and the state covers everything else. Because in birth injury cases,
Yeah.
in high exposure cases, 20, $50 million potential verdicts on a case or incident where a split second decision may have been the wrong one.
Right.
That's tremendous exposure, and
Yeah. We'll lose doctors for that.
here. So
Yeah. Well, it's fascinating. Well, just to end, I don't know if there's advice that you give folks or advice that's generally just sort of good practices right now for those in the risk industry that are thinking about this law. Is there anything that we should be thinking of doing next or monitoring or?
I think at this point uh, that they should be buoying healthcare providers, should be buoying their risk programs. I think they need to be attentive to incidents on the unit. I think they need to follow up. I think they need to bolster and make their risk programs more robust. And that's also medical groups to attack these things early on,
Yeah.
as you mentioned earlier,
Yeah.
because the exposure, it couldn't be 4 or 5-fold what it was this year, in the coming year. And there's going to be more claims and more lawsuits. But the sooner we get to this, and frankly, from a defense side, the sooner we can avoid a patient going out and seeking the services of an attorney, uh, we can talk to that person and try to resolve it
Yeah.
rightfully.
Yeah.
Uh, that's
So
what.
that's great. Yeah, I mean, so for those who have been thinking about CRP but haven't made it into it yet, this is another reason to dust off those efforts and try to get something in place. I think looking at reserves is probably going to be a natural part of this, probably already happening, certainly at the carrier level, but captives and, anything like that would be important. Does California allow captives? I don't know.
Yes.
Oh, okay. And the just the risk tower behind that and how the reserves are stacked against what's inevitably going to be higher payouts in general across the board.
Yeah.
Well, this has been great. Scott, thanks for educating me on this. It's always good to hear from somebody who's really in the middle of this. Any final thoughts before I close this up?
No, I know in my job, I'm so privileged to represent those who heal others. And I am, in my years of working with them, uh, these are wonderful people, the folks that provide for others. And I stand by them, and it's a privilege to do that on a daily basis in my work. And I wish them the best. And I know from the defense bar standpoint, my colleagues in defending them, I know we're getting ready for what we expect to be an onslaught of new matters, and so be it. We'll be ready.
Nice to know you guys are ready, and that was well said. Thanks so much. Well, for everyone else, thanks for listening to Reimagining Healthcare, a new dialogue in risk and patient safety. Subscribe and share if you found the value in this episode. And if you'd like to participate as a guest, as I mentioned, just email us at speakers@medplace.com. And last, make sure to follow Scott. I'll put your LinkedIn, if you prefer that, in the show notes. That'll be a great place for those who have questions and follow-up to be able to find you. And yeah, Scott, thanks again for the time. This was really great.
Jared, thank you so much. And thank you to MedPlace for the opportunity to present here today. Best wishes.
Our pleasure. Thanks so much, Scott. We'll talk soon.
Take care. Bye-bye.